This podcast is going to bring you the latest and greatest, most up-to-date information on disability discrimination cases and reasonable accommodation cases. And these are cases that were in this office that we got decisions on, favorable decisions, and what we can learn from these decisions that can apply to your case out there. First case, Datavius Coleman against Alex Azar, Secretary of the United States Department of Health and Human Services. This was one of the COVID cases. Very interesting case. The plaintiff, Mr. Datavius Coleman, he is employed as a procurement analyst, GS-12, in the Office of Acquisition Workforce and Strategic Initiatives for this agency. He had an excellent record of work performance. He also has some disabilities of depression, irrational fear. And by the way, all of the information that I'm giving you is all public knowledge. These are all published opinions by the federal courts. You can look them up. This one is case 20-02032, and it was brought in the federal court of the District of Columbia. So, October 16th, 2019, Mr. Coleman submits a reasonable accommodation request. It's backed up by a letter from his physician. It asks that he telecommute, not every day of the week, but he telecommute every day except 2 consecutive days in 1 week, the same week per month. That means that there will be 1 week in the month where he will be at the office for 2 days, so that if anybody needs to see him, they can. And the rest of the time, due to his disability, he wants to telework at home. Seems easy enough. About a month later, the first-line supervisor says, no, your reasonable accommodation request is denied. Worse than that, she mischaracterizes, she changes what he asked for. She says, this is a request for full-time telework, and we're not going to give you full-time telework because you have to be here. Okay, so that's one thing the government does, is they change around what you've asked for. And you got to be careful when you see that. You got to fight that. So they make this guy come in, and they were giving him at some point several days a week to telework. So he just wanted to beef up his accommodation, and they refused. Now comes the humorous part of this case, because now this part of the case I explained to my 8-year-old, and he laughed his head off about it. And it was something like this. Okay, they told this poor guy, we need you here. You can't work at home as much as you want to. And then guess what happened? COVID hit, and guess where they told this guy he had to work at home full-time. My 8-year-old just laughed his head off when he heard about that, because the case is so stupid. And the case basically is, well, what do you mean he has to work full-time at home? You told him he couldn't do that. You told him he had to be here. You listed all these reasons why he had to be at the physical location. What happened to all that? And basically, each side moved for summary judgment, and Judge Boasberg, James Boasberg, he is a very fine judge in the District of Columbia. He summoned the parties together, and he said, listen, how many days, Mr. Fischer, did this person actually have to come into the office because he didn't get the accommodation? Because they gave him some accommodation. So what was the total loss here? Well, Judge, I think it was 4 days. So the judge said, 4 days, I want this case settled. And the settlement was for, among other things, $27,000. Yes, but if you look at the ratio of what the injury was actually worth and what he got, you're talking 20, 25 times what the value of the injury was. The injury that you get is not necessarily a small one. It may seem like it's small, but 20 to 25 times the value of that injury is huge. And if you apply that to other cases, you've got a formula here that can really, really affect your career because we live in such a competitive world where sometimes the difference between the next promotion or not is based on some small thing or seemingly small thing, like in Annie Thompson's case against Wilbur Ross. This was in the federal court of the state of District of Maryland. I remember this case was recent and it was hard fought. The federal government generally is represented by a number of U.S. attorneys in the District Court of Maryland. One of the toughest ones is a woman named Tara DeShields. Folks, if you have a case in the Federal District Court of the District of Maryland, and that case is being defended by Tara DeShields, you are going to have a fight on your hands. This is a very tough and very good U.S. attorney. Call this office because that woman does not lose often, but she did in this case. And it was a case we had, Savitri or Annie Thompson against the Department of Commerce. It was decided by Judge Stephanie Gallagher. Judge Gallagher is an excellent judge. She was appointed by Barack Obama in 2011 at a young age of 38 or 39 years old. And Judge Gallagher has a very bright future, and not just because she rules for me, but because she's very intelligent, writes very well thought out opinions, and this was one of them. In this case, the defendant contended, that the plaintiff's low rating, Ms. Thompson's low rating, wasn't that important, didn't really affect her career, which is something defendants argue all the time, that whatever happened to you, who cares? The court cannot rectify every slight, every time your supervisor didn't offer you a cup of coffee and offered it to other people, stuff like that. And the court said, Judge Gallagher said, no, this case is different because that rating that Ms. Thompson got affected her ability to maintain certain certifications for her contracting officer representative duties. She was a COR, and she had to get that renewed. A renewal required a certain rating. She didn't have that, and the court said this can cost somebody. All right, so the court denied the summary judgment to the defendant. And also, it's in this case, Ms. Thompson had her telework privileges revoked. The government said that she had deficient medical documentation. The court said, no. Her 12-year-old daughter was ill, and that necessitated her absence from work. And this is another example of the court really looking at what the defendant does and saying, we're going to really scrutinize what you have done to this person here. And we're not simply going to accept blanket statements like, you didn't submit the right paperwork. No, Ms. Thompson really did. Again, this is a case of someone who had her career impacted. She had a disability, and this case settled for an undisclosed amount of money. Finally, the third case we want to talk about here, Leland Cogdell against Emily Murphy. This is an interesting one. This is one against the GSA. Mr. Cogdell worked for the GSA for almost 15 years. He had attention deficit disorder and a slew of other issues, but he was doing excellent work over the years. The government changed his job requirements and changed his job duties. So he listed through his psychologist a number of reasonable accommodations that he needed: a quiet room, noise-canceling headphones, feedback on work product, and a job coach. Well, guess what happened here? The agency grants him all of these things except for a job coach. And then they argue on summary judgment, look, Judge, we did everything that we were supposed to do. We gave this guy a reasonable accommodation. He didn't need the job coach. He hasn't shown us why he needed the job coach. And the court throws that out. And the court says, no, he really did. Okay. And if anything, this is another case where the government hasn't shown why he didn't need the job coach. And this is Judge Rudolph Contreras. He writes a really good opinion here, and this is in the Federal District of Columbia. And one of the cases that he cites is this Edwards versus EPA case, 456 Federal Sup 100, a district court case in the year 2006. A very important case for federal employees on reasonable accommodation, because the government always argues in reasonable accommodation cases that if you could do your job without the accommodation, then we really didn't have to provide you the accommodation. The court says, no, because under the Rehabilitation Act, the rule is that the accommodation that is sought simply has to be effective. It simply has to, quote, enable a qualified individual to perform the essential functions or to enjoy equal benefits and privileges of the employment. Meaning it simply has to help you do the job as well as everybody else. That's it. If you can show that and they didn't give that to you, such as the job coach, this thing goes to a jury to determine that. And actually, the government here is lucky that the court, as of yet, hasn't thrown out their defense and said there's no reason here for even a trial. You didn't give them the job coach, and that's pretty straightforward. You should have. And that's it. Mr. Cogdell lost his job as a result of this. And this is another one of these cases where the damages can be enormous. A seemingly small thing, like I didn't get a job coach, in the world of law, that's not such a minor thing. I mean, a lot of times you just don't know. These cases are not whiplash, where 3 days after you've been rear-ended, you kind of sort of feel better, and if you can wrench $5,000 out of an insurance company, wonderful. I mean, you're talking about major injuries here. Small things, small mistakes, or small I don't cares, which defendants are good at, large companies are good at, federal agencies are good at. You don't have to prove racism here or anything like that. All you have to show is the government didn't care about this disabled guy or woman. And they could be liable for a lot of money in these cases. And this is the message that I think if we go all the way back to the Coleman case. And again, it's not necessarily the amount of money, but it's why that case is so important is because it's the ratio of the damages versus the amount of money the plaintiff was actually out. And it shows how something can create great value. And if you think about it, that's how careers are. Your career is a series of small things on a daily basis or a weekly basis that are done well. It's the sum of all of those small things that count. Any one of those things, if taken away from the federal employee or from the employee at the large company, that could be gigantic damage to that person's career. So if one of these things has happened to you, call us. We can help you. We also invite you to become a subscriber to our YouTube channel where you can follow all of our podcasts.